consulted with my colleagues. They said it's okay. So probably we'll say a few words about arbitration at the beginning. Let me welcome my colleagues. I'll start with Maria Mazawi. She's the registrar of Arbitrate AD. Arbitrate AD is the Arbitration Center of Abu Dhabi. Dr. Imad Hussein, he's a figure in arbitration actually. He's well-known arbitrator. My dear colleague here, Muhammad Hafiz, from Dubai Arbitration Center, Dubai International Arbitration Center, DIAC. It is well known in the world. I think in terms of volume of cases, it is the largest, Maria. They compete. Yeah, recently 3 arbitration centers here in Dubai, they merged. So basically there was EMAC, Emirates Maritime Arbitration Center, and another one, the IFC, LCIA Arbitration Center, and DIAC, Dubai International Arbitration Center. They all merged, and now we have DIAC International Arbitration Center. So basically, that's an introduction. Just a few words about the British University in Dubai. It's not non-for-profit university. It was established by a decree by the ruler of Dubai back in 2003. It is, I would say, the first university to launch PhD programs. PhD in education, I think, was the first here. PhD in project management, if I'm not mistaken. Some unique programs like the Master of Construction Law and Dispute Resolution with the help of King's College London, and many, many other programs. So please visit our website. Sorry, they did not hear anything? I don't have. I'm sure you don't want me to repeat. Okay. So I move the mic now to my dear friend, Dr. Muhammad Hafiz, who will. Is this one? All right. Who will moderate this event? Thank you.
Hello. Thank you everyone for joining us today in our special events held here in the British University in Dubai, and special thanks to Professor Ayman Masada for hosting us here. My name is, as mentioned, my name is Dr. Muhammad Hafiz. I'm Special Counsel at the Dubai International Arbitration Center, DIAC. I'm truly privileged to be moderating this event with such an esteemed panel and such an interesting topic, as Professor Ayman has already mentioned, which is enforcement and challenge of arbitral award in the mainland UAE. 7 years and 1 round of amendments later to the provisions of the Federal Arbitration Law support or hinder enforcement. So basically today's event will include 3 themes of series of interactive questions posted to our fellow panelists. We'll try to keep it interactive so that it wouldn't be just one person giving a speech and then we move to the next one. So we'll keep it interactive. The first theme is legislative framework and 2018/2023 amendments. The second theme is judicial practice and enforcement trends. And the third theme is practical implications and reform outlook. We will then open the floor to our audience for questions and answers. So Professor Ayman Masada has already provided a brief introduction about each of us, but if you wish, since the mic was not working, that I can give quickly a brief of each of our speakers. So first I start with Professor Ayman Masada, who is the Dean of Faculty and Business Law at the BUiD's, as most of you know. He's an experienced arbitrator in the business law. He's a fellow of the Chartered Institute of Arbitrators and a board member of the International Construction Law Association. He's on the panel of various arbitration centers. Professor Masada conducted training courses on arbitration, construction, civil law, foreign direct investment damages, and legal ethics. On his left, Dr. Imad Hussein. He's a senior advisor at the Singapore International Dispute Resolution Academy, the SIDRA, an independent international arbitrator, accredited mediator, academic and published author. He is empaneled with leading arbitral institutions and served as mediator with the World Bank, CAO. On his left, Ms. Maria Mazawi. She's the registrar of the Abu Dhabi International Arbitration Center, or as we call it, Arbitrate AD, and co-vice chair of the CIR UAE National Committee, a trilingual civil law qualified dispute resolution specialist. She has over 14 years of experience in the Middle East, serving both as arbitrator counsel and counsel in international arbitrations across the multiple jurisdictions. So we have a very experienced panel, and I hope that the discussion will be quite engaging. Now to our themes and questions. As I mentioned earlier, first theme is focused on legislative framework and and 2018/2023 amendments. This session or this theme will be for a period of 30 minutes. We will give each speaker 3.5 minutes to provide their response to each question, to keep it flowing. So let me start first with Dr. Ahmed. Dr. Ahmed, considering the publication of your latest book on international commercial arbitration in the mainland UAE and with LexisNexis, I'm aware that your book has covered in great detail the historical journey of the Federal Arbitration Law. Would you like to start by telling us what were the key objectives of the 2018 Federal Arbitration Law when it replaced the old regime?
Thank you, Dr. Muhammad. First of all, it's a pleasure to be here in British University in Dubai, and I'm so pleased this morning to hear a lot of story of success about this prestigious academic institutions, and congratulations for the journey you've done and the other milestones ahead. And it's also my privilege to be one of the advisory board here of this university and to be here today. Back to arbitration. The journey for legislation, actually, it was almost 2 decades. And just imagine moving from 16 provisions in the old civil code into 61. This moving from 16 and 61 articles, it's not an easy. It needs policymakers, it needs registration thinking. So many of the practitioners in the UAE are not aware that this journey has been taking 20 years. 20 years in order to move from being just the provisions in the old civil code into the first standalone national law. The objectives of introducing this new legislation, just let's make it very simple. Imagine in your right hand, you have 2030 vision in the UAE. On the right hand, you have the principles of the 50. On the right hand, you have a very inspired and inspiring leadership in the United Arab Emirates. With this, I would say economic ambitious, there is no way to be here, leading, pioneering, exceeding the expectations of the investors, of the parties, and on the left hand, you do not have the stand-alone National Arbitration Act. So breaching the gap or filling the gap was the first step to have this legislation. So the key rationale and motivations of having this legislation, one, in order to let the investors invest here and arbitrate here. Two, in order to bring confidence, because having just 16 provisions in which so many things absent, we can talk about this later, this standalone national law, it triggers confidence, trust, and attracting the parties. The final point is that, and this is something you may think about, in the UAE, do you know how many arbitral institutions in the UAE, in this country? We have DIAC, we have Abu Dhabi Arbitrate, and you have in every single emirate there is arbitration. But all these, arbitration center, but all these arbitrations, they do not have one legislation, standalone national law. This is before 2018. So that legislation was mandatory in order to streamline and in order to fill the missing gap for the aspirations of the United Arab Emirates. This is in brief about the legislation, Dr. Muhammad. Please. Thank you.
Thank you very much. That was very, very insightful. Ms. Masawi, now to you. Some critics argue the amendments missed a chance to clarify issues like tribunal powers on costs or capacity of signatories. Maria, from an institutional perspective, what is your view and what role can institutions play in bridging that gap?
Yes, I've got.
You have a mic, okay.
Yeah, absolutely.
It's okay.
In terms of what institutions can do, so just to take a step back for those not too immersed in arbitration, the tribunal's authority to award costs and legal fees is a bit of a hot topic in arbitration, because historically we've had arbitral awards denied enforcement on the basis that the tribunal has exceeded its authority in doing so. So it's become quite a hot topic of
which provisions have most frequently triggered challenges to arbitral awards?
Thank you for this interesting question. I just want to elaborate to what Maria just mentioned. It's just, I think what's missing in the law 2018, or the arbitration law, more than certain provisions. Of course, there are provisions, I mentioned some later on, that we have problems with. But I think the law of 2018, although it is an encouraging and interesting step in the arbitration industry in UAE, is still missing points. One of them, the legal fees, that Maria just mentioned, that the tribunal doesn't have the authority to decide or to rule on the legal fees. The legal fees, the advocates' fees. The tribunal has the authority to decide on the cost of arbitration, apart from the lawyers' fees. But now, of course, with the rules of arbitration, the arbitration centers, if the case is what's called institutional arbitration, now we're fine. We rely on the rules. Sometimes we get the parties to agree in the terms of reference, or they sign the procedural order one. That will help us as well. But as a law, the law itself does not provide for this. Another point that, just example as well, the signature forms. The signature still, although the law made a good step that signature now, it's quite clear that doesn't have to be made in UAE. For 2018, I met a colleague of mine who traveled from Australia to Dubai just to sign the award and to go back, because there was an understanding that the domestic arbitral award must be signed here in UAE. And of course, there's a winning party, a losing party, and of course the party who lost will try to find ways to challenge the award, and this was one of this. Still, until last August, we had problem on where to sign. IAC asking us to sign every single page. Arbitrate AD, I think we had to sign every single page. But luckily there is a case. We'll keep signing every single page. How is looking at me? No, we'll keep signing every single page. But there is a case right now which says that, okay, you can sign the last page, and this is the authority of unification of the said that it took side of the Ras Al Khaimah Cassation Court and said that, okay, that was the right decision. You don't have to sign every single page of the award. You can sign the last page. But this effort could have been saved by providing a single provision in the law. And there's a list. Just to be fair to legislators, to those people who drafted the law is a big step. And it came at the right time, 2018, because remember, 2019, COVID started, and there was a question whether we can conduct arbitration online. The law helped us, because the 2018 arbitration law opened the gate for online arbitration. So it helped us much. There are lots of things to go. Yeah, emergency arbitration. Like people who work in arbitration will know that this is a very important thing. There's nothing about emergency arbitration there in the law itself. Just some provisions there may be interpreted some of it. There's no express, really straightforward provision that you can rely on that. The rules, yes, we find. So yeah, that's my mind. So that's just a brief that I think this law should, which is normal, the law will be looked at, will be revised, I think, in the future. Thank you, sir.
Okay, thank you very much. That was very insightful. Just a quick remark on the judgment that was issued from Ras Al Khaimah. It involved a foreign arbitral award that was coming to be enforced in the UAE, and so the way we are dealing with the matter is looked at from a different point of view.
Yeah.
But it always depends on the jurisdiction where you're enforcing it. That also always has to be taken into serious consideration. But the institutions can almost always try to help, but the most important thing for them is that we make sure that the enforcement happens, and we can always provide for other solutions, maybe in the future.
We will sign all pages.
But it's okay. I mean, I'm just saying, we can look forward to that in the future. Okay, now I move to Dr. Ahmed once again. Some critics argue that amendments missed a chance to clarify issues like tribunal powers on costs or capacity of signatories. What's your view?
Yes, thank you.
talking about this point, historically, let's just think in the following. The Federal Arbitration Act law, FAL, or sometimes they call it FAL, this is the last jurisdiction of arbitration in the Gulf states. In Saudi Arabia, it was 2012, in Bahrain 2015, in Qatar 2017, and UAE 2018. So Oman 1997, because Oman comes after Egypt, 1994. So being the last arbitration jurisdictions coming, or legislation, peaceful legislation, it is supposed to be the least, the latest one, the pioneering, the leading, and to get benefit from others. But it seems to me this didn't happen. Of course, as Professor Ayman enforces right now, it was a big step, a big move, but we should not utilize the opportunity, but optimize the opportunity. That is the first point. The other one, that did we miss the opportunity? Indeed, yes. Because simply, the issues of uncertainty related to the legal capacity in Article 4 and the issue related to the causes in Article 46, they are still with an ambiguity that affect the arbitration friendliness. So if I'm going to do any reforms, legislative reforms, I should focus on what brings the raw arbitration friendliness, and decreasing the level of uncertainty. So this didn't happen. Additionally, and this is, I have to be very frank, there is a misconception in our region. We keep talking every day, every morning, that we are following the UNICETRAL model law, United Nations. Yes, and this is not the role anymore, because that model law, it has been enacted in 1985. The needs of 1995, the expectations of 1985, the economic situation of 1985, the economic competitiveness of 1985, completely different now. So if you keep doing what you are doing, we'll keep getting what you are getting. So it was expected in these amendments to think beyond the UNICETRAL. And that's what the English Act of 1996, the latest one that has been enacted 2015, they did so. So in brief, there was a golden opportunity, and we hope in the forthcoming, like now in Saudi Arabia, they are bringing new legislation now completely entirely, because the evolving needs are different, and if you didn't control the future will control you. That is, I think, the best opportunity. Thank you.
Thank you. Professor Ayman, back to you again. There has been notable progress in the UAE's approach to the admissibility of claims and jurisdictional objections. In your view, does the current law and the practice in this area align with international best standards?
Yeah, I would say now, yes, it does. Let me just start with some information where this question perhaps comes from. There are some arbitration clauses which we call like multi-layers or multi-tiered arbitration clause, dispute resolution clause. So basically, you start with the engineer. That's in construction mostly. So you start with the engineer, and then you move to the dispute adjudication board. So you get a decision there. If you are unhappy with the decision, then of course for that is trial for amicable settlement as well. And then the last resort will be arbitration. So basically, the decision of the dispute adjudication board, which is very similar to the arbitration process, is binding but not final. Can be final after the lapse of a period of time. So what if you bypass what it is? What if you go to arbitration? What if you don't try seriously with adjudication, and nevertheless you go to arbitration? I think this is the question. So I would say previously the idea is that we don't have jurisdiction, as jurisdiction means for some people who are not arbitrators here, that competency, that I am competent as an arbitrator to decide the case. So previously we used to decide that dismissal for no jurisdiction. I don't have the power to decide the case because the dispute was not escalated in the right path. So that's what. Until I think recently, the summer of 2023, when there was a decision by the Cassation Court, first Court of Appeal and then Cassation Court, I think Judge Nabil Amran was the pioneer of that. So basically there was an interesting decision which simply says that this is not a matter of jurisdiction. Because the tribunal has the jurisdiction, they can decide the case. It's a matter of whether the claim can be admitted or not. And it's a matter of admissibility. And this aligns with the international standard. Of course, the difference is big. When you talk about admissibility, that means it is in the hands of the tribunal, basically, and it cannot be a ground for challenge for that reason per se. Of course, you can rely on what's called due process, not fair treatment, and so on. But you cannot say that it's a matter of jurisdiction, a matter of legality, then admissibility, then it's in the hand of the arbitrators themselves. The other interesting point that I would say also aligns with the international standard is that now the tribunal, if the tribunal is convinced that this claim was not escalated in the right way, the tribunal may stay the case, stop the procedures, tell the parties, go back, complete the pre-arbitration procedures. If you do not reach a total settlement or a partial settlement, then you can come back to us. So basically, in terms of partial settlement, there can be a partial consent award. In terms of total settlement, come back to us as well, but we will issue it as a consent award. So basically, right now, I think the practice, with the help of the court, aligns with the international best practice. And one thing that we need to keep in mind is that I think that the courts in the Arab world need perhaps to realize their role better than the current situation right now. That their role is not to decide on a single case like an arbitration. As an arbitrator, I decide on a dispute, and that's it. But the court may help the industry, may guide, as this case, just one case, change the practice in UAE and help the legal industry save a lot of efforts, a lot of money by just a single case. So this, I think now the answer will be yes, it's in line with the international standards. Thank you.
Thank you very much, Professor Ayman. Back to Dr. Ahmed. If you could propose one reform to the Federal Arbitration Law, what would it be and why?
Yes, please.
Thank you, Dr. Mohammed. Before proposing any reform for the Federal Arbitration Law, I would say that what is the impact of this reform? What is the results that it can be brought to the community? That is one consideration. The other consideration, we need to compare with the top-ranking jurisdictions for QUIMAG surveys. And as you know, QUIMAG surveys started in 2006 until 2025. They issued 14 surveys. In each single survey, they assess the jurisdictions, the arbitral institutions, and legislation. So if we revisit the QUIMAG surveys, or even if we visit London principles, they are also, assessing what make a certain seat attractive. If we revisited both combinations, and that's what have been outlined in my recent book, if we did this visit objectively, intentionally, scientifically, practically, and cascaded the same on the UAE, I think we can come up with several legislative reforms. But on top of that, I think in 2025, we shouldn't no longer talk about legal capacity. If I am the CEO of a company, and I'm talking about Article 4, think Article 4. If I'm the CEO of the company, or the chairman, and I am authorized to do deals of millions, and to do merging, acquisitions, and to go beyond the sun, to do everything, am I not allowed to arbitrate? Am I not allowed to arbitrate? This is really ridiculous. And in every single jurisdiction in the world, if you can buy a car, by default, you can buy and sell a bicycle. So this Article 4, it's completely against, and by the way, you will be laughing right now. I have conducted a quantitative and qualitative assessment of 170 court sessions, 170 between 2019 and 2022. out of 170 court sessions, there are 47 annulment case in relation to legal capacity. The parties, after the award, final award has been issued, they went to the court, good morning the court, good morning, comment ça va bien? Please, the guy signed this arbitration agreement, is lacking legal capacity, while he is the chairman, while he is the CEO, while he is the manager. So this should be entirely eliminated. And in 2025, if you really want to lead, you have to bleed. You have to bring something that, yes, I am in alignment with Arbitral, yes, I am in alignment with best practice, and yes, no more for this guerrilla tactics to waste the time, even of the court. That is the crucial and the most important legislative reform. The other one, if you allow me, Dr. Mohammed, the other one, in brief, I know the time is crucial today. The other one, to revisit Article 53 and Article 55, the grounds for annulment, because among these grounds, there are some grounds that shouldn't be existing at all, especially those related to the public policy and public order. Public policy should be well defined in order to reduce the amount of the work for the annulment. And I think those are the two key areas for adaptation. And again, that could be a repetition, but within the edifice of these reforms, we should revisit the question: do we still have to be in full compliance with the Arbitral model law, or it is the high time to think beyond the Arbitral model law? It is the high time now. It is almost more than 40 years. So that is the position of. Otherwise, we will keep the load of the jurisdictions. Now, most of the court judges, they are doing their best to avoid the annulment and to find the way within related to Article 4. Why shall I bother their life? Why shall I make their life hard? They have other mission to do other than the interpretations and find the way. So that's really what we have to do, because the parties, the investors, the arbitrator, the institutions, the surveys, when they come to you and they find any areas of uncertainty and ambiguity, you are still categorized as non-arbitral or non-arbitration friendliness. And that is the last point. Why this question is only here in the UAE and in our region? In Paris, in London, in Singapore, in Hong Kong, in so many jurisdictions, nobody's asking you about how is your legal capacity for arbitrate. This question, if you ask it in Singapore, where I'm working right now, it will be ridiculous. Oh, what are you talking about? Do I need to have a legal capacity for this? Do I need to have a special power of attorney? So all these areas, I think, should be clarified. Otherwise, we will keep with these areas of uncertainty, and we will not be able to lead among the top-ranking jurisdictions.
Very interesting.
Thank you, Dr. Ahmed. This was very elaborated and very interesting.
And you can ask him about his research method. Qualitative and quantitative. That's dangerous.
But it's untold the reality.
Okay, now back to Maria. From an institutional standpoint, which provisions have most frequently led to award challenges? And how might centers better guide parties or arbitral tribunals to mitigate these risks?
Sure. I'd say, well, I'm hard to say that so far we haven't had a single arbitrate award challenge. So I'm not speaking of arbitrate experience, but private practice experience. I think I'll address the three main ones, which is the first one is the hot topic of capacity, which I completely agree with. It's something that needs to be dealt with as soon as possible. What we encourage tribunal members to do is at the very outset make sure they iron this out. They ask for a power of attorney. They go beyond the power of attorney as they need to ask for additional documents to evidence authority, and they add wording in whether it's procedural order 1 or the preliminary documents and proceedings to say that the parties are satisfied that they have the requisite authority to participate in these proceedings. The case management office is also empowered to ask for proof of representation. So this is something we're very attuned to very early on, and we're quite open with the tribunal on how we can collaborate from an institutional perspective and the tribunal to just iron out the issue at the outset. The second one, I think, is in also quite an issue, but from an institutional perspective, the way we deal with it is through scrutiny. So at Arbitrate AD, we scrutinize awards on two levels by the Case Management Office and the Court of Arbitration. We take a lot of pride in our scrutiny process. It's quite a hands-on process. We obviously don't interfere with the tribunal's authority to determine the merits, not at all. But we check for the hallmarks to make sure the award is well-reasoned, there are no miscalculations, it addresses the claims that it needs to address. In case it inadvertently misses a claim, we flag it to the tribunal, or if they phrase things in a way that might come across as even perhaps suggestive that they're exceeding their authority, we flag it to their attention, just to make sure that the end objective of an arbitration is an award that can travel, whether it's in the jurisdiction or is seated or elsewhere for enforcement. So what we try to do is make sure that it's as safeguarded as possible via scrutiny, and we look at all the grounds to which you can annul an award and have that at the back of our minds when we do scrutiny. And I'm conscious of time, but the last point I would say is notification and notices. This is very much on an obligation on the institution to make sure that's as ironclad as possible. So, for example, at Arbitral we've got a case management platform called Docket AD, and we undertake e-service. And one of the things that we can do as an institution on Docket AD is check when a party has accessed a document. So sometimes we get a party a couple of weeks in saying, I was never notified, and this is the first I've heard of it. And we go to our logs and we say, actually, you've heard of it 2 months ago. You downloaded the document, you accessed it 4 times. So we make use of that tool to make sure that that part or that gap is also ironed out. So there's a big role that institutions can play to sort of plug those little not so little gaps.
Very much. Thank you very much. So just the last question to both of you, Maria and Dr. Ahmed, but very briefly, please, so we can be mindful of the next themes. Is legislative reform still the best way to solve these problems, or can judicial practice compensate? I give to Dr. Ahmed first.
Yes, thank you. I think, Dr. Muhammad, this is a twofold question. Let's have a good example about that, about whether it's mandatory and important to have crystal clear, drafted and well-crafted piece of legislation first to enable the judges in order to work, to make their mission easy, or also the courts, it has to consider that. In the current Federal Arbitration Law, the two provisions for the getting the award aside, one of them is the violating of public order, public morality, and the non-arbitrability. Although that this is the second reason, but in the article, I think, 54, they refer only to the first one, which they missed referring to the second one. In spite of this legislative, I would say, default, but in the 170 court sessions, I did the assessment, all the judges, they have interpreted the legislation with their own understanding, with their own legal characterization, which means they are supporting the legislation, although there is a lacuna or there is a gap, which is really great from the judges. I have never come across any session that's having literary translation or literary interpretation of this provision 53. But again, this is the example, but can we guarantee that every single judge will have the same way of thinking, the same outcome? We cannot guarantee that. So, back to your questions of the default, definitely, the well-drafted legislation is important for the court prove arbitration stance. And that is the situation in the English Act. Although the English Act, it has helped in making London as an attractive seat, an attractive hub, but they revisited the entire provisions and come up with a few reforms for nothing other than helping the court and enabling the court while deciding on the annulment while deciding in the enforcement, especially the issue of enforcement is crucial in international arbitration. So the legislation is important as well as judiciary. The good example of that, in Singapore, the legislation, or the legislator, I would say, they never take any action in relation to reforms without the involvement of all the stakeholders. And that's why during our last meeting with the Supreme Council in Singapore, they have what they call industry meeting, quarterly industry meeting. All the judges in charge of enforcement, the lawyers in charge of enforcement and arbitration, every 3 months they have round meeting and focus group and start discussing what can be done better, what went well, how can we be a truly pro-arbitration from legislative perspective, how can we be a truly pro-arbitration from judicial perspectives. And this 3 quarterly meetings, it is published. It can be accessed by the public, and you can read what they are doing, what they are discussing. The same in UK when the Law Commission start working on the legislative reforms for the English Act, and also the Law Commission when they start working on the mandatory mediation. So in brief, these are the 2 iconic, and in my book I found that the 3 pillars, there is no way for arbitral institutions to be really efficient without the support of legislations, and in between, judiciary or the court cannot bring the best reputation of the seat without having a well-drafted piece of legislation. That is the edifice of that. Thank you. Thank you.
I'll be brief. I completely agree. I think neither exists in a vacuum nor operates in a vacuum. You need to have a solid set of legislation that supports arbitration and sets the general framework in a manner that's not too restrictive, but also sufficiently addressing the critical points. But you equally need a judiciary that is not just supportive of arbitration, but that is attuned to the sensitive nature of the hot topic points of arbitration. And just to give some credit to the Federal Arbitration Law, I think one shift that was very noticeable to see pre and post FAL is the way in which the judiciary used to refer to arbitration. Before the FAL, they used to refer to it, the word in Arabic escapes me, but something equivalent to unusual or special. Exceptional, yes. And then after the FAL, now they just say alternative. So it's an equal balance of both. You will always have parties that test every single sub-article of the law, and it's on the judiciary to maintain the spirit of the article, or the wider point, to maintain the arbitration friendliness of the jurisdiction. So I'd say both of them equally so.
Thank you very much.
If you allow me, Dr. Muhammad, just half a minute. For this, I think, Maria, you triggered a very important thing. Just very brief. It's okay now? It's okay? I hope it's fine. It's fine.
Yeah.
Perfect. Maria, thanks, Maria, for bringing this point. Out of the 170 court sessions, one of the questions, how did the court refer to arbitration? And we have 3 questions. Exceptional way of dispute settlement, or alternative method of dispute settlement, or parallel method of dispute settlement. The good news, until 2019 and 2020, the majority of reference to arbitration, it was exceptional, because the mindset of the judges, their perception that this is something different. We are the court, we are the judiciary, and this is the arbitration. But starting in 2021, the increasing number that arbitration is a parallel method or mechanism for dispute resolution, which is really great. And when I start digging into to see where did they start referring to arbitration as exceptional, I found that the Court of Cassation in Egypt in 1971, this is the first court sessions in Egypt in 1971, they named or titled the arbitration as the exceptional way of method of dispute settlement. And from 1971, all the court sessions in Bahrain, in Saudi Arabia, in the UAE, and in other jurisdictions, they just follow it until they woke up and they come, hey, no, we're working together. We are working in parallel. it is not the title, it is not the issue of the title, Sir Dr. Muhammad. It is the issue of when you say it is exceptional way, it means that you are in undermining position. You are not equal. This, I mean, the impact, this perception, it has its own legal implications in enforcement, in annulment, in recognition, and in the arbitration friendliness. So it is not just a title, exceptional or alternative. By the way, in Singapore, we are not using the word alternative at all. We're using it appropriate means of dispute settlement. Thanks, Maria, for bringing this point. It was only half minute, as you can see.
Thank you very much. That was all very, very helpful. I just want to make one remark as well. Like for instance, just like Singapore, Hong Kong as well does the same thing. So when before they issue their ordinance or their law, they would actually consult with the Hong Kong International Arbitration Center and other stakeholders in the city, because eventually they want to align themselves. So for instance, the law came out, and then the following year they updated, the Hong Kong International Arbitration Center had updated its rules. This in hand would increase the choice of the seat of Hong Kong, for instance, or other countries that would follow suit. So the role of the judiciary in always consulting with the stakeholders in the same country, I think plays a major role in the choice of the seat. So that's definitely one of the things that I just wanted to highlight very quickly. So now we move to the next theme, judicial practice and enforcement trends. We have 30 minutes, so basically 4 minutes per question, or maybe give or take, maybe a bit less. We'll see. We try our best. We hope it's just being engaging, and we're always happy to give more and more information. So for Dr. Ayman, to start with you, do you see a clear trend towards pro-enforcement in UAE court decisions, or is the picture still mixed?
Yeah. Good question, but difficult one.
Without consent.
I'm just trying to be objective. I think it is yes, but at the same time, no. Okay, let's start with the good side. Yes, because if we go through the court sessions, yes, the tendency is very positive. I think the percentage of annulment, by the way, out of 170 court sessions, the percentage of enforcement 87%, which is great. This means only 13% have been annulled, and that's a good. I mean, and when I did the comparison of this percentage with other top-ranking jurisdictions in arbitration in London, in Paris, Hong Kong, Singapore, it's almost within the same rate. The only challenge, the duration. We are still, in terms of duration, it takes longer time. So it is yes from this perspective, from the perspective of the arbitration friendliness from judiciary. And it is yes, as Professor Ayman just noted now, the recent decisions of the unification, commission in the UAE. Yes, the last court sessions about that the signatories and all of this, and they compare between the attitude of Ras Al Khaimah Court of Cassation, Abu Dhabi Court of Cassation, and Dubai, and ended up yes that Ras Al Khaimah is really pro arbitration. That's yes. It's also yes that the participation from judiciary has been changed. Yesterday, an example of that. Yesterday evening from 6 to 7 in Sharjah book exhibition, I was really honored to have a very interesting discussion. And who are the panelists? The chairman of judiciary, the chairman of the police, the general prosecution chief, and His Highness Sheikh Sultan, the Deputy Ruler of Sharjah. And you have been all talking about what can we do in order to make Sharjah more friendly in arbitration and more taking further steps into amicable settlement of disputes. That is something very healthy. I mean, 10 years ago, it's too difficult to invite a judge from Court of Cassation or Court of Appeal or from judiciary to be with you and to listen to you and to listen to your voice and the choice. That was too difficult. But now in Dubai Arbitration Week and in other events, I can see that shift, that move, and they have become more open to listen to you. How can we help you? That's really the yes. Shall we move to the no? Move to the no. My answer about no, that sometimes the lack of consistency, the inconsistency in the court sessions. I mean, as mentioned by Professor Ayman, just one court sessions affect the entire ecosystem, about the interpretation of the seat versus the venue, about the legal causes. These decisions from time to time, it affects the whole scene. And I remember that in 2017, when the penal code has been changed in provision number 257 to incorporate the arbitrator in case of any violation, and I think the penalty is until 10 years imprisonment, that was 100 steps back. But again, now here in recently, we can see judiciary have become more open. They are still, but what's lacking, to be honest, capacity building. I think, and that's one of the recommendations, it's very important that the judge in charge of considering and managing the final arbitral awards in Ras Al Khaimah, in Abu Dhabi, in Dubai, and in different legal frameworks, because we have, as you know, we have the onshore, we have the offshore, we have the different legal frameworks within the ocean of the UAE. This understanding and this perception into arbitration is still there. There's little gaps. So we need capacity building in terms of training, in terms of understanding. And to conclude, in Singapore, it is not allowed for the judge to be in the bench for arbitration unless 1 year has been completed, full understanding of the 16th provision of New York Convention, full understanding of the 34 or 36 provisions of International Model Law, full understanding of the ecosystem of Singapore, what Singapore is aspiring to do within the economic competitiveness, and the final request to provide a research reinforcing the understanding of the ecosystem of arbitration within Singapore. At the time, he or she is allowed to consider arbitration. I think that's what's lacking here in the UAE. It's also another half minute.
Very interesting.
Very
interesting.
Professor Ayman, one of the principal grounds for challenging arbitral awards concerns the validity of the arbitration agreement itself. Do you believe that arbitration agreements made by reference are adequately addressed under the UAE law and practice?
Thank you. I think this question is related to mostly construction cases, by the way. When parts refer to FIDIC contracts, the red book, yellow, and others. So basically, in such contracts, there is an arbitration clause, and the parts refer to this as part 1 of the contract. These are general conditions, and they add, of course, particular conditions. Now, the issue is whether referring to the general conditions of FIDIC red book, for example, will be enough to say that parts agree to an arbitration, because there is an arbitration clause, dispute resolution clause, in these general conditions of FIDIC red book. This is the question. Now, I have to say that the law, I cannot say new law because I think it's a brand new law of arbitration law in UAE complicated the matter more than making it easier to understand. And this is reflected in the recent cases. For example, Article 5 of the law speaks clearly that there must be a clear reference to the arbitration clause. Whereas if you go to Article 37 of the same law, it says that if you refer to a model contract, and I think they mean standard contract, where it has an arbitration clause, then the arbitration clause is part of your contract, without saying that there must be a reference to arbitration. In a recent case, the court decided that since there was no clear reference to the arbitration clause in the standard contract, then there is no arbitration. And actually, we were hoping that things will get easier when it comes to the arbitration agreement rather than more complicated by the law 2018. Before the 2018, it was an understanding in UAE across all courts in FIDIC contracts, in construction contracts. When you adopt the FIDIC, that means parties agreed on arbitration. Now, with the new law, it's not necessarily. So we have to go back to sign the page where the arbitration clause is, And if there is a reference to an appendix to the contract where there is an arbitration clause, if parts want to incorporate this into their contract, they will have to sign the page where there is an arbitration clause in the contract. The court wants a clear reference to arbitration clause, and in what the court wants to make sure that parts did agree on arbitration as a form of dispute resolution. And I don't think that this is a move in the right direction. And I think in addition to what Dr. Imad just mentioned, that talking about CEO who signs a contract of multi-million, I think the CEO should have the authority by default to agree on arbitration. Why we are going back, see whether he has the authority. The same, if we have a reference to a standard contract that has an arbitration clause, this must be interpreted as an agreement arbitration. If there is one of the appendices of the contract that has an arbitration clause, there must be this must be interpreted as an agreement on arbitration. So that's my point. I think the law, the new law, and the interpretation of the rules of law in the hard manner, I would say, made it difficult to adopt arbitration agreement by reference. I'm not saying that's impossible, but my advice is that to make a clear reference to the arbitration clause in the particular conditions if you want to adopt arbitration, or just copy and paste the arbitration clause in the particular conditions, and that's it. Much easier. Thank you.
Thank you very much. Maria, on the same point, so given the current legal environment, how can counsel best draft arbitration clauses to minimize future challenges?
Well, easiest solution would be to opt for model clauses depending on the institution you'd like to select. But I think what I've seen from my experience in an institution and my experience outside of it is dispute clauses tend to be drafted, one, by non-disputes team, and two, in the honeymoon period of a contract where you think nothing ever is going to run to a wrong. And I think there's a lot to be said about needing to educate non-disputes teams about the importance of drafting a solid arbitration clause, in which at least just go and use a template in institutional rules and tweak it as you need. Make sure that you cover all the basics. Make sure you have a number of arbitrators. Make sure you have the seat, the governing law, the language. Yes, institutional rules will have provisions that account for situations where you don't agree on any of these things. But at least if you use the model clause, you avoid, for instance, having pathological arbitration clauses or badly drafted arbitration clauses where there's a unilateral right to go to arbitration in favor of one party. Those are easily avoidable mistakes, and it ends up always, you see them much more frequently than you'd expect, is what I'd say. So I think the biggest and easiest win is to just either opt for a model clause or make sure to consult disputes colleagues on what to avoid in arbitration clauses, just to mitigate that risk for when you need it. When you need it, you're not, it's just avoidable clause.
I agree 100%. I think also one last point is the capacity building. I think the whole aspect of, even if you cannot consult the legal team or focus on dispute resolution in a law firm who can give you this point of view, you can also consult, you can take courses and understand how to draft arbitration clauses for in-house counsels that you believe, because the company would invest in millions and millions of dollars, and eventually they can end up with a pathological arbitration clause because just they didn't. So I agree 100%, and I think the capacity building as well plays a major role in that aspect. Thank you. To Dr. Ahmed and Professor Ayman, both of you, are procedural defects such as signature irregularities or notice failures still leading to annulments? Dr. Ahmed, please.
Thank you. Just building on what Maria shared right now, I'm so pleased to share with you a very interesting project in Singapore who are working on this, and this is an invitation for the IAC and the Arbitrate Abu Dhabi to join us or to have something similar. What we are doing now, we are working in collaboration with SIAC, Singapore International Arbitration Center, to work on 2 years project to do full analysis of 250 arbitration agreements, pathological clauses, defaulted clauses and to issue a guide, of course, after the permission of the parts, and to issue a guidance of the legal difficulties, the linguistics challenges, the what went wrong, and how to improve this. And this will be a guidance for the in-house counsels, for external counsels, and this project will really part of the capacity building, because that is the way. If you have a guidelines of 120 arbitration agreements defaulted and having gaps, either in legal gaps or linguistics or drafting, that is a treasure in itself. So I strongly invite the IAC and Arbitration Abu Dhabi to find their own way, doing this, because that will really enhancing and empowering the councils, and to be more aware, especially if they had seen the similar examples of what they are doing. I think that's really will be of importance. Back to the procedural irregularities, I think yes. It's still enhancing, it's actually affecting the arbitration friendliness in the jurisdictions. And back to the 170 court sessions, as far as I remember, almost 13 to 17% they rely on this, of the irregularities in proceedings. So if you make sure, and I think the IAC in its rules, I think March 2022, am I right? March 2022. You have addressed all this in an advanced perspective, and I think we need to ensure the uncertainty within procedural irregularities have been already well addressed, both in the legislation and arbitral rules, and that will minimize the number of annulment cases and will make really jurisdictions or the hub or the seat a truly friendly, a truly efficient, a truly effective. And by the way, such questions we are discussing here, there is no space for similar questions in other jurisdictions because they are already behind. So we need, and I'm sure we'll be there, we need to one day to be similar to Singapore at a seat, similar to Hong Kong, similar to London, similar to other leading jurisdictions. They are already been ranking in Queen Mary surveys and also in our Cedra surveys. And all these questions have become part of the past. There is no way to keep talking about legal capacity, about procedure, about the other things, because that is the hidden cost. And we are working on another project now, the hidden cost of having uncertainty and ambiguity in arbitration legislations and rules. That's also because it's all affecting the seat. Thank you.
Have anything to add?
Difficult to add what you mentioned, Dr. Ahmed. Just few words. I think procedural justice versus substantive justice. So basically, procedural justice is not less important than substantive justice. So we'll talk about regularities, we'll talk about procedures. We have to put procedures. Parts agreed on that procedures. Parts agreed on following the rules of the IAC or the rules of arbitrate AD. So we have to take full consideration of this. But when I go back to the question about signature, for example, whether it causes problem, yes, until now, actually I cannot understand why we have to sign each page of the, we'll keep signing it. But why we have to sign each page of the award? I mean, the award can be signed at the end, the last page, and that's it.
To satisfy the wet ink.
So sometimes the award, by the way, is just like 400 or 500 pages, and you have like 5 copies to sign. So you have to, you have to do some exercises there while you are signing. First, the last signature will be totally different from the first one while you are signing. So there's no need. There's no need. The award will be with the parts at the end, and if there is any problem with the award, anybody challenge the award or sends the award to the court to enforce, the other party is there to say that this is not the right award. So basically, there is no need. And until now, actually, I advise my colleagues to sign every page because we do not know how the court will approach this. We have decision by the Unification Authority, which is really binding and excellent, but I don't know whether anything will change in the future. So yeah, signature is very important, and I think we need to keep signing every page.
Back to Maria now. Two questions for you. First one, from an institutional perspective, what are the most common mistakes parties or councils still make that jeopardize enforcement?
I would maybe widen that question slightly to say not just enforcement but proceedings, and it's not even reading the rules to, treating deadlines as optional, to not participating in tribunal constitution, and then, at the 11th hour coming in and say, actually, I now want to nominate someone, but you should have, he's already went to court. There's a lot to be said around that, I think.
I think it really depends on the experience of the counsel to deal with the case. If they're
100%,
experienced, then they will know
Yeah.
how to,
I think there's an assumption, sorry not to cut you off, I think there's an assumption in the market as well that, there's a huge understanding of arbitration. There is, and that's why arbitration leagues and jurisdictions is excellent to have, but I think we tend to take for granted that, yes, we see a lot of colleagues and friends in arbitration leagues that we, have across each other in cases, but a large part of the market share goes to perhaps inexperienced firm, and I think that's not addressed sufficiently. And we need to figure out a way to reach the larger market share that is perhaps taking on a lot of the smaller cases, but equally, those smaller cases form a huge part of the market, and those counsel are very active on smaller cases, which does not necessarily mean they're lesser than cases. They can have equally as many complicated points or procedural complexity
Or
as
more.
high or more, and probably more because of their experience sometimes,
Exactly.
which makes it, trickier.
They make it more
So I
complicated.
think there's a lot to be said around reaching out to the full spectrum of the market and making sure that these points of discussions and awareness around arbitration, the sensitivities of the procedure, because the procedure works, you just have to know how to work it. It's as simple as, so I think there's a lot to be said around that.
thank you, Maria. Another question. How does the court's handling of challenges based on public order and capacity of signatories impact the procedural administration of cases by institutions? And how can institutions actually help parties to avoid these pitfalls?
I think we try to stay, obviously, any institution needs to stay attuned to the developments of the jurisdiction in which they're operating, but also neighboring jurisdictions, as well as the international developments, obviously. But I think the case management office needs to be very much ears on the ground. You can't really alter the way you handle cases on a case-by-case basis. The approach needs to be uniform. But there's a lot that goes into sort of trying to prevent the early hearings that you see, and liaising with the tribunal at the very outset and saying, look, this is something to sort with the parties. We offer the tribunal checklists when we transfer the case file of points to get the parties' agreements on. Can the tribunal sign their awards with e-signature? We have an entire electronic signature law in the UAE that recognizes e-signature. We have a provision in the Federal Arbitration Law, and e-signature on arbitration awards is still an issue. It's still considered controversial. So we have a long list of things that we really encourage the tribunal to address with the party at the very forefront of proceedings, just to try and get party agreement as much as we can on as much as we can.
Thank you very much. Dr. Ahmed, this is the last question for the second team. Could you please share a recent case that illustrates a shift in judicial reasoning?
Yes, I think, am I audible? I think it's fine. Okay. Okay. Before sharing this example, let's have a comic relief out of the drama. Sometimes we are talking, we need to have comic relief. One was a very interesting example that last August I was a visiting professor in Singapore, and I have received, I was one of the members of the tribunal, and received 60 copies of original arbitral award, and each copy, it's almost more than 75 pages, or I think 80. And I sit in the reception in the hotel, and I told the gentleman, please just let the DHL is coming in 10-15 minutes, I will finish the signing of the award. And I found that I spent over 3 hours just with the whittling, just keep signing the pages, and then the DHL representative came and collect these pages. And the guy come and asked me, sir, if I may ask you, what are you doing? I told him, no, this is something too confidential. It should be signed. Oh, I'm sorry, sir. Because people are wondering, in 2025, with all these technology, with the AI, with the electronic signatures, are there really this, and this is completely against the environment. It means that this is arbitration anti-environment to sign all these pages. So that's very interesting, and I couldn't even tell the gentleman what I'm doing, because that even cannot understand. Back to the positive, progress. I think first of all, there is a tendency now among the judges, which is really great. We are very grateful, and we should appreciate what they are doing. And instead of getting the award annulled, they are trying to find the other reasons for corrections, interpretation, doing whatever to avoid the annulment. And that's really the trend that I have seen in Court of Cassation in Abu Dhabi, in Dubai, Iraq, and others. So let the annulment to be the last resort. That hasn't been the case 5 or 6 or maybe 10 years ago. That's one good progress. The other good progress, the partial annulment. I mean, especially in relation to the legal costs, we have seen that, especially in Dubai Cassation, there are so many cases in which, or awards, final awards, that they have been partially annulled because of the legal costs. So you keep the other provisions or the other components of the awards is fine. This is not fine, but it will be fine.
Nothing serious.
The last but not the least.
Okay, we try to raise our voice.
We got it. So the last progress, I think it was too difficult previously for the Unification Commission to agree on signing the last award. The last decision issued in this award, very proactive, very progressing, and it reflected that we are living a new era of judiciary perception to arbitration. By the way, originally speaking, you will find in every single jurisdiction, in Egypt, in Saudi Arabia, in Bahrain, in every single jurisdictions, the role of the court now, it has been redefined, and the perception and the real addressing of arbitration has been positively changing. So there is a good progress here in this regard.
Is this working? Sorry.
Thank you.
I'll just speak higher because I think the mic might not be working. So
This one's working.
everybody's here.
That's fine.
Okay, great. Just making sure.
That's,
Okay, now I move to
Mike's
the
theme.
third theme, and the last one: practical implications and reform outlook. Still 4 minutes for each, give or take.
This is a reminder for my own.
That's everyone. So, Dr. Ahmed, back to you again. Has the UAE's approach to enforcement improved its reputation as an arbitration-friendly jurisdiction in the eyes of foreign investors? You don't have to. It's fine.
No need.
It's not working.
Good. Okay, that's really another very interesting question. Let us agree on the following. If we are working and talking right now from London, Paris, or whatever the jurisdiction, top-ranking jurisdictions, and you are talking about the UAE, the first impression that will come to the users will be the offshore GIFC and ADGM, simply because they are accessible, simply because they are common law based, and simply if you need to assess the legislative framework, the court sessions, everything is accessible. So the perception about the UAE is divided into two tiers. Tier 1, or the first cluster, about the offshore or the free zone, mainly GIFC and ADGM. Oh, thank you. This is the bonus. Thank you. Okay. I think that is the perception. So let's put it this way. There is a positive perception to the offshore in the UAE, because the offshore, that in terms of certainty, clarity, lack of ambiguity in legislations, in court sessions, it's really perfect. And that's why, originally speaking, Bahrain recently has established Bahrain International Commercial Court, aligned with Singapore, SICC. And the good news about Bahrain now, the appeal from the court will be considered and handled in Singapore by the International Court of Singaporean International Commercial Court. So that's the perception about the offshore and the free zone. However, the perception for the mainland, which my book about the mainland, is still there is skepticism about the mainland for several reasons. First of all, lack of accessibility. I am an investor from Belgium. I need to know the court decisions of let's say, Ras Al Khaimah or Dubai or Abu Dhabi, and I need to visit the court website to review the court sessions. Sometimes I can reach this, but in most cases, either there is no translation or lack of accessibility, or I mean, it's not easy. And so the lack of accessibility to the courts, that's one of the reasons. The second reason, from time to time, such inconsistency affects the reputation, because I am, why shall I come to a jurisdiction in which I am not aware, or there might be some risk associated with the outcome? So that is, I think, the challenge. But practically speaking, and by the way, the users are following the perception. Users are not following the reality. So I would strongly recommend, since we have DIAC and we have Arbitration Abu Dhabi, we need to bring statistics, we need to bring figures, we need to show cases to the outsider parties that the mainland, we do have a story of success, we do have a pro-arbitration judiciary. All these illusion, all these, I think, perception should be shared with the end user, because until now, to a certain extent, the offshore UAE and the DIFC UAE is which is true, is the one that you can rely, is the one that you can go for arbitration, is the one that's really more bendable. And also, and this last point in this regard, I'm so pleased that the policymakers start realizing that we need to fill the gap between the onshore and the offshore, the mainland and the free zone, because at the end it is the competitiveness of the country, it is the vision of the country. So we need to fill the gap in terms of the perception to arbitration, and that's why in your rules in DIAC, it was in March 2022, and the new rules in Abu Dhabi Arbitration, I think, January 2025, I think, February. So yes, so 2024. So I mean, in the last 2 years, even the institutions start being part of this progress to attract, to reinforce confidence, and to be also part of judiciary.
Thank you very much, Dr. Ahmed. Professor Ayman, in ad hoc arbitration, the court may appoint an arbitrator. Do you think this may restrict the tribunal on ruling on its own jurisdiction?
All right. Okay. I think this linked to a recent decision. It's very fresh from the open, I think 2 months ago. It's the idea when the court appoints the arbitrator. Can this arbitrator say that he or she doesn't have jurisdiction? That's the question. Doesn't have jurisdiction over the case. So the idea or the understanding was that since I was appointed from the court, then I don't have such a jurisdiction. Then I will have to go on with the case. Sorry, I don't have such a discretion to decide on my discretion, jurisdiction. So basically, I will have to go on with the case. A recent decision made clear that when the court decides to appoint an arbitrator, it's clear that's an appointing authority. So it doesn't examine really the arbitration clause. It doesn't examine the merits. It doesn't examine whether the arbitrator will have full jurisdiction to decide on the case. So it is something on the face of it. They look at the arbitration clause, there's an arbitration clause, then they go on with the appointment of the arbitrator. So yes, appointing an arbitrator doesn't mean that the arbitrator will not have jurisdiction to say that, will not have discretion or power to say that there's no jurisdiction, there's lack of jurisdiction, and he can decide on this matter freely. This is very similar, by the way, to the institution of arbitration. The institute or the arbitration center will refer the case to the tribunal by looking at the arbitration clause on the face of it, but does not deprive the tribunal from any power to decide on its jurisdiction. So deciding on whether the tribunal has the power is competent enough to decide on the case, whether in terms of the formation of the tribunal, if anything is related to the escalation of the dispute, although I just mentioned that's a matter of admissibility now more than jurisdiction, anything related to the issues presented to the tribunal, to the validity of the arbitration clause itself, the scope of the arbitration clause itself. So all of these matters will stay in the hands of the tribunal, of the arbitrator, even though the appointment authority is the court or the arbitration center. So it is the same.
Agree. Yes, thank you. I completely agree with you, Mr. Ayman. I think the fact that you have an arbitration clause that is ad hoc and refers to, for instance, UAE arbitration in the UAE, or and you resort to the court, so the court makes the appointment as an appointing authority, and it only decides on the method of the appointment. So, for instance, it mentions that it's the number of arbitrators shall be a sole arbitrator in the case. That is the method that it does. But the law itself provides the arbitral tribunal, once it's constituted, to rule in its own jurisdiction. So I think by default that is the fact that we're dealing with. So I completely agree with you. Ms. Mazawi, what recurring missteps by parties or counsel continue to jeopardize the enforcement, and how can arbitral institutions better educate users on these risks?
It's slightly similar to the answer I had before, which is, well, I'll tweak it now to say active case management, because the worst kind of case management is a sleepy case management, and that starts all the way from the institutional end to the tribunal. So that's number one, because you're a steward of procedure when you're an institution, and equally when you are an arbitrator or tribunal. Yes, you're dealing with the merits, but you are the steward of procedure. It's your task and your job to make sure that things go as they are required to go under the rules in such a way to ensure that the outcome of it can travel and can go into enforcement, and that you haven't missed the potholes that some parties might try to set up throughout, which they will do. So I think that's number one, being very active on case management, whether you're institutional or the tribunal. But the second, again, I go back to the same point, and I appreciate it's repetitive, but I feel very strongly about reaching out to make sure that there's enough education to the wider market. It's a very critical point that I don't think I really appreciated when I was in private practice, but having crossed into the institutional end and having seen a much wider array of counsel, there's so much to be said around that. And I think one of the best ways to achieve this, yes, is of course through conferences and seminars, but also through cross-institutional collaboration. I think it's very important, and it's something that I'm trying to actively do through my role in CRBs, just to make sure the institutions come together and give an offering back to the market to say, look, there are free resources out there. Yes, each of these institutions offer courses and the like, but there are free resources out there that are meant to be there exactly for this purpose, which is to aid you to understand arbitration, to make sure, model clauses was an easy example of that, because they're easily accessible everywhere on every single website. You can easily call up an institution. Obviously, an institution is never going to offer legal advice, but they can point you to where that model clause is and tell you this is option one, this is option two. They're in our rules. Feel free to have a look. So
The other website.
they're on every institution's website, but I think there's so much to be said that people don't even know that.
Yeah.
You interact with a certain share of the market in arbitration week. It's a share of the market, but the reality is this is the market. So we need to reach it all the way through and make sure that these principles of arbitration are well understood, because what I've seen feeds the most in terms of setting up potholes and proceedings to try and jeopardize an award. Yes, part of it is intentional, but part of it is just miseducation, misunderstanding, and failure to appreciate the consequence of rule X and why it's structured this way. So I think that's what I think.
So it's either inexperience or maybe dialectic tactics that can be used by some counsels, and even though they don't know that it is, they don't even know that it is dialectic, they just do it because they don't know.
Sometimes they're sneaky and they're
sometimes
intentionally.
I agree. But I think the most important thing is to have an arbitral tribunal that is experienced and to know the levels of what is for due process, and when a party exceeds its mandate and it starts acting in a way that can be quite disruptive to the proceedings, this is where it really plays a role. And having also the arbitral institution being careful in making sure that everything is done according to procedure, I think that's very important. So
If I can add to that, I think just on the experience of the tribunal, obviously it's not just on the experience of the tribunal. I'd say a tribunal that's I don't want to say the word courageous because it's not really that, but a tribunal that's not going to be bullied, or a tribunal that doesn't have paranoia of due process. And same applies to the institution, because that's the very essence of dilatory tactics and guerrilla
such as in the case of missing the date or the place of signature, should the courts send a word back to the tribunal and avoid annulling it?
Yeah. I think this question was partly answered by Dr. Kamal. He just mentioned that the court somehow is pro-arbitration, becoming more, I wouldn't say use the term lenient, but saying that finding ways to keep the award alive rather than allowing the award. So this is the point. There are mandatory elements of any arbitral award. One of them, for example, is of course signature. Other thing, the date, the place, seat, arbitration. So if something is missing that can be added easily by the tribunal, why should we annul the award? Can't we just send the award back to the parties to add these elements? That's my point. So basically, if you find a legal system, a judicial system that's pro-arbitration, the court will try to find ways of keeping the award alive rather than allowing the award, trying to send back the award to the tribunal to fix the things that can be rectified easily, because these things that can be added or corrected somehow by the tribunal. Of course, there are things that can be ground of annulment. Talking about the invalidity of the arbitration clause, talking about the lack of evidence, lack of due process, lack of notification of procedures, and so on. So these things you cannot rectify really by the court, but there are things that you can rectify, you can fix, rather than jumping to annulment. Just send it back to the parties and to the tribunal, to the arbitrators, and let them fix these things by adding the missing elements or fixing the elements. And to be fair, and to give the judicial system here in the country their credit, in recent cases, this is the attitude of the court. So the attitude of the court to try to keep the award alive by partial annulment when it comes to the legal fees and attorney's fees and this, or by trying to ask the tribunal, the arbitrator, to fix something that can be rectified easily by sending it back to them. The law allows this. The law actually more than allows this. The law, I think the legislator wants that, rather than, because we talk about arbitration in some cases that cost millions and time. By the way, arbitration is supposed to be fast and less costly, cheaper than. But the fact is, when it comes to complex construction cases, the arbitration takes a long time and is more expensive than the judicial. So annulment of an award shouldn't be taken lightly, and the court should take all reasonable procedural steps to keep the award alive.
Can I add a comment to that?
Yes, please.
You're
Yes.
Yes.
You have that.
That's okay. I think that illustrates that illustrates the point of how important institutional award scrutiny can be, because it serves for that function.
And you are doing very well in that.
We've got Dr. Ayman on one of our cases in a scrutiny coming up, so I swear it's not for that reason, but that's why it's so important, because it sort of serves that function to try and preemptively offset an attack against the award, and that's the lens that we look at it as, and we give it back to the tribunal to say, do you want to consider fixing this? Do you want to consider fixing this? So it sort of illustrates that point of how important it is to have a robust institutional award scrutiny. Of course, it does not touch the tribunal's authority to determine the merits.
Absolutely.
Not at all.
Yeah.
But it just sort of, I want to say, bubble wraps the award to make sure that it can survive and go into enforcement without having, to go through all these things.
And I think we should give credit to the new development in the centers, that with the new rules, there's what's called scrutiny.
Yes.
And this is something new.
Yes, of course. The reviewing of the arbitral award or the scrutiny of the arbitral was very important, because it allows us to take a look into the award, make sure that everything on the procedural aspect, specifically on the procedural aspect, is well noted and drafted. And that is very important, and that is what makes these less challenged, or not challenged, but set aside. But for ad hoc proceedings, that brings us back to Professor Ayman's point. I just wanted to note one thing. So under the law and under the institutional rules, you have a period of time where you can do the correction or the additional award, or you can do it in an interpretation. So we have all of these features for a specific period of time where the councils or the parties have an opportunity to look into the award and make sure that it's fixed. By the time that the deadline finishes, the 30 days correction period, the tribunal's mandate is finished and it's over. So it's not possible that you can go back and ask them to fix it. And that's where the problem comes when you go to the court and the states that, of course, it passed, you try to enforce it, and the court tells you, I need further clarification on this point, tell the arbitrator to do it. But he doesn't have a mandate, and that's very important. So what can be a solution to this issue? Maybe, since it is the court's mandate to make that request, it has the power to revive the arbitrator's power to edit or provide further interpretation to the award. And that could be something that's subjective, but for instance, for arbitral institutions, it is not possible. For us,
Absolutely, yeah.
it does not work.
Can I comment on this part? I agree with you totally. Actually, when we talk about institutional arbitration, when the period is over, the period is over. That means you can never go back through the institute to touch on the award. But the question is whether the court has the power to send the award back to the tribunal or not. Now, this is controversial matter, and I would say yes. If it's a matter of things that can be rectified, the court should have the power. Now, do we need really clear provisions, some kind of amendment of the law to make it clear-cut case? Yes, I would say yes. But to say that the court, for example, cannot send back the award to the tribunal to add the date so that, and to annul the award, that's, I think, extreme. That's too much. Probably in order to be pro-arbitration and to give credit to the arbitration, the court should have the power to send back to the award to the tribunal to fix that thing that can be rectified easily. But I agree, perhaps a clear-cut legislation is the way. Yes?
I was just gonna, I think there has to be some stuff in there to
Yeah.
calibrate what is considered a correction, because you will have a party, and we've had that on one case recently where they filed an application to correct an award because they disagreed with the finding. It was literally a correct, the finding is incorrect, and I've asked for this and they didn't give it to me, which was not in the guise of you missed the claim, but I just disagreed with your finding. And so that's a very clearly, I'm trying to reopen the award because I didn't get my way application. And I think there needs to be a check in place, similar to how institutional rules, at least ours has an early dismissal of claims, something along those lines for correction applications. Is it a correction application, or is it a, I'm not really happy with what I got?
Absolutely right. I can't agree more, actually. Right now, if they ask for a correction award, then the institute will have to send it back to the tribunal, but perhaps the institute can have the authority somehow.
It does, but within the 30 days period, unfortunately, and if it does happen, the tribunal, by the way, answering Maria, I think the tribunal has the authority to say, sorry, we cannot do that. I agree.
If you just give me a chance to
Yes,
jump on this one,
yes.
this is really crucial. That's, and even we can skip other questions if for the time. I'm sorry. I'm sorry. That's crucial. In one of the industry meetings in Singapore, we have found this dilemma. The arbitral institutions, they have a checklist of what the tribunal should do. Unfortunately, not all the arbitrators abide by this checklist. That is from institutional, perspective. On the other side, we found that also the councils, they have challenges in the proceedings. So we agreed, and this is I think only a few weeks ago, we agreed in Singapore that in order, and we are lucky because most of the arbitral cases, they are institutionalized arbitration, not ad hoc, not like here in the UAE. There are some few cases in Saudi Arabia. It's much better. It's almost 80% in ad hoc. So let me share with you, if you allow me, Dr. Muhammad, what did we do in order to have good beginnings and good ends? One, judicial judiciary in Singapore, they provide SIC, Singapore International Arbitration Center, with every single aspects of the annulment of awards, which are very, few cases. But the center is aware of the grounds for annulment and the challenges the judiciary have. So they take it into consideration either in the reforms of the arbitral rules or in dealing with the councils or in capacity building and the training. So that is the relation. Just imagine here in the UAE, if the arbitral institutions, they do have this collaboration with judiciary in which they get from the judiciary the feedback about what's happening after the award has been submitted for enforcement. That is one approach which I think very effective. The other way, I think at least 3 to 4 times a year, all the internal councils and external councils, they receive training on the arbitral rules of SIC, of the center, in order to be more aware, to be more oriented, and the center, they have a checklist of what's still not yet attending this course. So by the end of the year, they want to make sure that every single council is having the opportunity to be aware of the checklist, to be aware of the proceedings, to be aware of everything related to the mechanism of arbitration. That makes the center a third in ranking worldwide. That makes the judiciary among the top 5 judiciary in the world. That makes the seat effective and efficiency. So it is not just one stakeholder. It is from institutions and from judiciary. So what I want to say here, I would love, and I'm aspiring that the judiciary, and of course you can take this initiative further, judiciary is having such a proactive role in working together, in sharing together, in growing together, in ensuring together that we are really working for the benefit of the seat repetition. Because even, we are all arbitrators here, and we are receiving checklists, and we are also having full support from arbitrations. But at the end, there are annulment, there are challenges. So where is the missing piece of puzzle? The missing piece of puzzle, it is the ecosystem itself, especially judiciary and institutions. I think that's really very important. And we are lucky, as Professor Ayman mentioned now, that the judiciary here start taking a proactive approach that, yes, we need to work hand in hand with the institutions. Yes, we need to find a better collaboration, and I think that's what we need to work into with the judiciary, because at the end of the day, judiciary that makes you alive in terms of arbitration, or it just makes you that your reputation is upside down. So that's something very important. Thank you.
Thank you.
So unfortunately, we will not be able to take the last 2 questions because of the time. We have only 10 minutes or 5 minutes. So I leave now to the audience the questions, and hopefully we can provide you with some answers. So if anybody has any questions.
Yeah, thank you for such a fruitful discussion.
Now, would you like to introduce yourself?
This is Dr. Dirar Dabobi. I'm a lecturer at the University of the BUiD's, the British University in Dubai. Actually, I have a question in terms, this refers to a case which brought before the Supreme Court of the United Kingdom 5 years ago. It was related to a contradiction between the independence feature of the arbitrator and the commercial secrets. It was related to a maritime case, which is insurance case. The problem was that the arbitrator refuted the other's allegation on the basis that I cannot disclose. As you know, that the duty of disclosure is very important for the independence of the arbitrator and the impartiality. So the other party was alleging that he did not disclose the relationship with one of the disputing parties. So, but at the end of the day, the Supreme Court So my question is, do you think that such a problematic issue is solved in the act of the UAE arbitration 2018?
Yeah, just very quick. When it comes to the confidentiality and conflict of interest, we usually refer to the IBA rules, International Bar Association guidelines, and they have labeled them with colors, where you can go ahead, where you have to disclose, and where you shouldn't take the case at all. And if you do disclosure, which is encouraged, I'm one of the people who encourages really disclosure. You shouldn't really disclose any confidential information or go in depth. You should just mention that about the relationship in general about this. Very interesting case that you mentioned, by the way,
Yeah.
about military secrets and this. But I leave it. I think Tornad will
Yeah,
add
please.
this. Yes,
That's really very interesting. Very
Yeah,
interesting.
yeah.
By the way, that case, one of the cases that has been considered by the Law Commission in the recent reforms of the English Act, that case. And the good news in the recent reforms of the English Act 1996, which is in effect from 2025, I think, they elaborated on the duty of disclosure, but they rationalize this duty of this disclosure in order in order to avoid any uncertainty or skepticism of disclosure. They have taken into consideration this point of commercial secrets or commercial, information that you cannot share. Honestly speaking, and from my own practice, is still this issue, especially if the parties didn't agree on the IBA rules for the disclosure and all this, and if there's a vacuum, this is for the discretionary power of the judge in ad hoc arbitration or for the senators in relation to this disclosure. But still, I think not yet clearly resolved. But this, in order to find a way forward for that problematic situation, sometimes I think the rules itself, and this is especially in GIAC and Arbitration Abu Dhabi, the rules maybe consider that the forms for undertaking, accepting the mission or the duty for arbitration and the disclosure, I think these undertaking should be developed, should be revisited in order to avoid such things for the future and ensuring a safe passage of the entire journey from accepting the mandate until the award issues. Maybe the forms and for the approaches for the undertaking and the disclosure. But still in the UAE, it is still existing. But in the UK, I think it is with the new amendments and with the reforms of the English Act, I think it is already cleared and it has become well crafted now. Thank you. Yes, please.
No, my voice.
Okay.
My name is Saadi Abu Georgi. I am an arbitrator and a court expert. I have agreed to the institutions upon assigning sole arbitrator is to look at the background of the dispute and assign a competent arbitrator that knows the industry. Just in a recent case where I was a case manager for one of the parties, the sole arbitrator was, I don't know from which background was that gentleman. And that affected the understanding of the arbitration. My plea is to assign a competent arbitrator from within the industry, at least to know, you cannot assign an arbitrator who has insurance background in a construction dispute. That's the only plea I have for the time being.
Can I address the point and also just what was
Yes.
discussed on the disclosure? So the way we appoint arbitrators at Arbitrate AD, we don't impose arbitrators on parties. So we approach multiple arbitrators at the same time to check for their availability. We ask for a statement of their availability, independence, impartiality, and acceptance. We also ask for the
exceptional.
Yes.
Do you want to add anything, Maria, or shall we go back to it? Yeah, perhaps any more questions?
Is there a microphone?
Yeah. Ah, sorry.
Is there a microphone?
Perhaps I can give you
I'll
one.
speak up.
Yeah,
I'll
yeah, that's
stand and
good. Thank you.
I'll speak loudly. Philip Punoir, practicing barrister, retired Dubai registered legal consultant, chartered arbitrator, 20 years president of Dubai. Firstly, what a wonderful panel. I'm so glad I jumped in my car and drove all the way from DIFC to get here on time to listen to an excellent presentation. How nice to see two competing arbitral institutions. How nice to see two competing arbitral institutions collaborating so productively on a panel like this. I'm going to tell you why I disagree with a few of the comments that have been made. Hopefully it's constructive. Firstly, having been involved, I'll put it another way, having spent several hundred hours drafting a draft federal arbitration law for the UAE back in 2007, and having spent dozens of hours as part of the DIFC 2008 Arbitration Law Steering Committee working on the 2008 arbitration law for the DIFC, I do not believe it's difficult to produce a world-class arbitration law. Furthermore, I don't believe that the UNCITRAL model law is out of date and not fit for purpose. It's a short law by modern standards, and it was never intended that it would cover all eventualities. And when you're drafting an arbitration law, you always have to augment the model law. But what's really important is that you do it clearly, and you make your augmentations or amendments as transparent as possible. And I believe that the UAE deserves to have the best arbitration law it can possibly have. And it doesn't have that at the moment. And that's curious given how, as a country, we race forward always pursuing the best. And we have achieved that in so many regards. So I would like to think that we will replace the existing arbitration law in the not too distant future, and we will not only have a world-class arbitration law, and it shouldn't be difficult to produce one of those, but we will take the lead and produce the best possible arbitration law that any jurisdiction could possibly want. Furthermore, I absolutely agree with how important it is to narrow the gap between mainland and offshore, the arbitration systems in both. And that was what we tried to do when we were producing the 2008 arbitration law for the DIFC, because we thought the draft that I had been working on with the Ministry of Economy stood some chance of making its way into legislation. It didn't, like many others. But what we did with the DIFC law is we took quite a few of the provisions from the draft federal law, we fed them into our draft for the DIFC, because we didn't want the two laws to be going in different directions. And so I agree with you absolutely there. So I again applaud you, and I would love to read your book, but I fear it might be in Arabic.
No, it's in English.
Is it? Is it in English?
And it is open access. It's open
Oh,
access.
fantastic. Okay. Well, I've got my homework for the next couple of weeks.
Thank you.
Thank you very much.
If you allow me, yes, that's. Thank you. That's really very thought-provoking comment. Thank you. I would like to just share with you. I can't agree with you more, but three important things, which is not well known unless you read the book. One, the Federal Arbitration Law drafting journey started in 1999. Most of the people here in this room and outside this room, they thought that it started 2006, others they say 2008, and when it started with the ATCAC. The first draft in 1999, it has been drafted by ATCAC in collaboration with the Ministry of Economy at that time. And from 1999, it has been taking 20 years until it has been enacted in 2018. In this journey, we have the following. After 2004, a draft by Ministry of Justice, 28 a draft by Ministry of Economy, and then 2010 a revised draft by Ministry of Economy, and from 2010 until 2017, silence. Nothing at all happening because Dubai is working separately and Abu Dhabi is working separately for their own domestic jurisdictions, and it has been kept for 10 years without doing any further amendments. And in 2017, because of the vision of 2030 and because of so many developments, hey, we should have a standalone national. Let's do it, let's finish it. And I have attended the last sessions or the last meetings, and that is the story of that one. But one of the most interesting draft, it was in 28, which was 100% similar to the one in Bahrain of 2015. It was based on the Arbitral model law. It is almost the same provisions of the Arbitral. I would love in 28, okay, this federal law to be only and mainly based on the Arbitral model law. That's the first fact. The second fact, maybe I didn't express myself well. What I meant to say, model law is a quality, and beyond the model law is the excellence. If you want to reach the excellence, you should have the foundation. No way for any jurisdictions to not to consider, even in UK, in Singapore, in Hong Kong, they consider and they have accommodate the unilateral model law to be the foundational basis, and then thinking how to amend, how to align, and taking into consideration the preparatory works of the model law, because this is for harmonization of the nations between. But within harmonizations, you should be proactive, creative, innovative in order to compete. So it is a foundational one. That is.
But one riposte I would have is I think legislative draftsmen are very conservative, because the draft that I produced with Issa Badur of the Ministry of Economy in Abu Dhabi was in English and Arabic, and it was the Arbitral model law word for word, but then we had a schedule that identified the additional provisions or amendments to the model law. And I think a draftsman of an arbitration law, an international arbitration law, shouldn't be sitting in the jurisdictions looking at their desk drafting an arbitration law. They should put themselves in the position of an international lawyer sitting in their office in Brussels late on a Thursday night, and the lawyer receives a call from his client to say, we need to sign this contract tomorrow. What do you think of the arbitration clause? He looks at it, he sees that it provides for a Dubai seat.
Yes.
He doesn't know anything about
Offshore,
arbitration
offshore.
in the UAE, but if he can pluck off the internet the UAE Federal Arbitration Law and see that it's in two official versions, like the Japanese Arbitration Act,
Yes.
English and Arabic, and he can just turn to this schedule that tells him, because it's drafted for him, what or her, what he needs to look out for.
Exactly.
His job is made so much easier.
Absolutely.
And there's more and more chance then of these leading UAE institutions becoming more than just UAE institutions, more than just perhaps regional institutions, but truly becoming choice institutions for practitioners and their clients from all over the world.
That's absolutely right. And my last point in this regard, and you will agree with me after reading my book, is that although the FAL has been drafted and come into 2018, which is the last Gulf countries, after Qatar and after Saudi Arabia, after Bahrain, after all these countries, it was supposed to be much more than that, because you have the other best practice, you have the comparative, you have the ADIFC, you have everything, but the key, from my own perspective, the key reason for having these lacunas, it is because of the judicialization of drafting. The last version has been crafted from judicialization perspective rather than the key stakeholders. That is the key reason based on the assessment we did. So hopefully, and I'm sure it will happen, when it comes into the amendment with pioneering experts like you and our colleagues here, if they make sure that all the industry stakeholders will be involved, that will be a poetic base of arbitration rather than just a short listed or something with default. Thanks a lot for your input.
Can I just one simple point? Although model law can play a significant for really any country that would like to excel in any law, but there are some local issues that we have to deal with, and if they are dealt with by provisions of law, things like time, efforts will be saved. We just discussed the signature, for example, the power of attorney, I think legal fees. These things I feel like more local issues for UAE rather than international practice or international best practice. So in order to deal with these matters, then we need really things customized to the UAE legal industry. And this can be done by a local law, okay, based on a model law. That's where you start with, definitely, but then you customize it to suit the local industry.
But you know, as I said,
and practice.
You have to customize the model law, but you've got to know what you're doing.
Yes.
And by all means, make amendments that you need to for local reasons, but they should be very few. But when you do that, make it clear that you've done it, and make it clearly available as
what
it
you
were,
intended,
to
what
the
you
non-specialist
yes.
foreign practitioner.
Absolutely, yes. Yeah,
Because
that's a very
otherwise
interesting
you're simply laying
point.
a trap for the unwary.
That's a very interesting point. Like when you do something different from what's there in the model law, it should be clear why you are
It's
doing
like an
that.
exclusion of liability
Absolutely,
clause in the contract.
absolutely.
Put it in red, in bold letters.
Yes.
Just one word here,
That's
because
what I feel like you have few words
it's
to say.
fine. No, it's fine. A very valid example about this, Bahrain. Bahrain in 2015, they have just copied the model law as it is, and they issue enacted, and they do just very refined, very minimum requirements, because they realize that if we take the model law as it is for their own landscape, for their own economic expectation, for their own competitiveness, for their own infrastructure, we found it's fine. And even in the preparatory work for model law, the countries are invited to be creative, but to be creative rather than to doing disruption. Because a big difference, as you mentioned now, between being proactive or having creativity in aligning the provisions and of distorting these provisions that will affect your competitiveness. So Bahrain, they did this approach in 2015. That's it. Yes, that's also.
We should have done it in 2007
Yes, definitely.
or 8 or 5 or 1995.
Yes.
We will. When there is a will, there is a way.
And further? That's it. Okay. Yes.
Yes. Thank you very much, everyone, for coming and giving part of your day to dedicating goodwill by coming to BUiD and attending our session. Thank you very much. Please, if you have any further questions or anything you need to ask, we can have it after the panel. So thank you very much, everyone. And,
Still. It's very valuable for us. 20 years. Thank you very much. So happy for you. Thank you. Thank you very much. Thank you very much. Just for Dr. Abdullah.